Good morning and welcome to Momentum Global Matters. My name is Ray Mere and I'm Head of Investment Distribution here at Momentum. With me in studio is my colleague, Kapil Joshi, who's the Head of Momentum Collective Investment Schemes. So Kapil, what do you think of our new three-dimensional studio here?
I think it's amazing, and I love how Momentum Investments has embraced the future with our events in the last 12 months. For all of you watching at home, let me tell you a little secret. None of this is real. Not the plants, not the couches, not the walls, the floors, or the ceilings. Ray, should we show them where we really are?
Why not? For everybody tuned in today, we have an incredible lineup of investment experts from around the world who will be sharing their insights and views about the past 12 months and also the road ahead.
But before we get to our first speaker, just a few things for all of you to note. Not only did we build our new beautiful virtual studio, we thought it also needed a home. You're watching this from our brand new Momentum Investments events website. This website has a couple of really neat features. At the top of the landing page, you will see that we give you access to our agenda, profiles for each of our speakers, and a great way to navigate this conference.
In addition to that, our download section has links to all the presentations, information packs from all our presenters, and links to video content you might find interesting. As we move into the future, this website will continue to grow and become your home for investment information. Our investment specialists are on hand to answer any questions you may have during the event, so please post your questions in the chat box for us to respond to them. If you need any more information regarding our capabilities or investment solutions, please request a callback and we'll get back to you as soon as possible. Kapil, shall we get the show on the road?
Let's do that. I'm joined in studio by Himna Landman, who is the Head of Momentum Wealth and Wealth International at Momentum Investments in South Africa, and Jeffrey Wiseman, the Chief Executive Officer at Momentum Trust Limited. Joining virtually from Guernsey is Jeff Gavey, the Managing Director at F&B International Trustees Limited. Jeff, let's start with you. Can investments get stuck in the Suez Canal?
Well, thank you, Kapil, and good morning, everybody. I think that's exactly the question that should be asked, and I think the answer is yes. So I'm going to talk to you today about the issues of offshore probate, or executorship as you would call it, and what you do when your clients unfortunately pass away and you need to try and help the family to obtain ownership of the assets. So as Kapil mentioned, I represent F&B International Trustees here in Guernsey, where we've been for over 40 years. We're the only offshore fiduciary services provider of the first rank group. So many of you will obviously have heard of us, and we cover pretty much the same function offshore as your fiduciary services companies would in South Africa. So the one I'm going to cover today is, as I said, the issue of offshore probate. So as Kapil said, it's a little bit like getting stuck in the Suez Canal. So I'd like to sort of, use my little slide, which I dredged up from the internet, just to add a little bit of levity into what is a fairly dry and boring topic. Let's assume your client has passed away and you need to help your family or the family to obtain title ownership of the assets. So the first thing you might try doing is sending them the South African letters of executorship and saying, here we go, can you pass the assets over to us, please? What you're going to find, though, is when you go to Guernsey, Jersey, the Isle of Man, UK, or pretty much every other jurisdiction in the world, the institution, bank, finance house is going to say, no, I'm afraid not. That holds no legal validity here in Guernsey or Jersey or wherever at all. So what we're going to do is we're going to have a look at all the roadblocks on the way and what exactly you need to do to bypass them and get your ship down the Suez Canal and back to Johannesburg. So the first thing to understand is the offshore probate or estate administration process is not entirely dissimilar to what you would find in South Africa. But our experience is that advisors will often understand that process, but they will then vary in anything from, well informed to completely in the dark. So my purpose is to take you through the sort of the high level processes that you can expect to find and, exactly how you can go about doing it and how institutions like ourselves can help you. So by the end of the short presentation, I hope you'll have a better understanding of what's involved, the costs, the timescales, the documentation, and exactly how you go about helping your clients. So the first thing is don't get worried about notes. There will be handouts, information sheets, fact sheets available in the pack at the end of the meeting. So as I said, the offshore estate administration process is not entirely dissimilar to South Africa. You have a master's court. We have in Guernsey, which I'll use as my first example, an ecclesiastical court, which is the last probably the last church court, I think, pretty much anywhere in the world. There you go. Lovely old sort of Victorian Georgian building in the heart of St. Peter Port. And there is where the local executorship process takes place. So as I said before, the South African letters of executorship has absolutely no legal status in the offshore world. So what you need to do is you need to understand firstly where all your assets are. Okay, so once you understand where they are, let's say in this case, you have a momentum wrapper in Guernsey. So the first thing you need to do is you need to have details of all the assets, and then you need to basically approach somebody called an attorney, someone like FNB International Trustees, in the place where you have the asset to act on your behalf. Then that attorney will ask you for a long list of documentation. Okay, so what you really need to know is you'll probably need to have a court-sealed and certified copy of the letters of executorship with the will annexed, a court-sealed and certified copy of the death certificate, the last residential address of the deceased, the maiden name, if applicable, and the value of the assets at the date of death. So you'll need to provide the attorney with copy statements of all of those assets, where they are, and then even more annoyingly, if the will is in Afrikaans, you will need to get a translation into English from a translator approved by the Master's Court in South Africa. Okay, so I think you can see that, it's not necessarily that difficult, but there is a fair package of documentation which will take you a little bit of time to get together. So once you've got all that together, you submit it to the attorney in Guernsey, and then what they will do is they will then issue a power of attorney for the executor to complete in favour of FNB, and then we submit all that to the local ecclesiastical court. Okay. If the ecclesiastical court is happy, someone from FNB, I've done it many, many times, goes to the ecclesiastical court on a Friday morning, puts their hand on the Bible and swears an oath in front of the Dean of Guernsey to faithfully administer the estate. As I said, all very, very quaint. So once that's happened, it takes about a week in Guernsey, and you will then receive what is called the Guernsey Grant of Probate. Okay, so spoken out like that, it sounds pretty straightforward, but I think what you need to understand is that from the time that you first approach an attorney, putting together the documentation, submitting it, getting the power of attorney sworn in front of a commissioner of oaths or a notary public, probably takes about 10 to 12 weeks, possibly even 3 or 4 weeks longer. Okay, so I think from start to finish, you're talking 4 months if everything goes well. So that talks to the timelines. I think the other thing there are court fees in all of the jurisdictions. So in Guernsey, for say an £80,000 sterling estate, you'll pay about £150. In Jersey, about 600. Isle of Man, about 700. And in the UK, about 100. On top of this, of course, you can add the normal executors' fees, which, not dissimilar to South Africa, are around 3%. So as I say, there will be fact sheets giving all of these details, but I think the key thing to understand is that the process is not entirely dissimilar to South Africa. It can take 3 to 4 months and perhaps even 4 to 5 in the Isle of Man and the UK. And there are costs involved, and there are charges, and there's really nothing you can do to avoid it. So I think the summary that you can take away is find somebody who can assist you, such as a firm like ours. We can deal with the Guernsey, Jersey, UK, the Isle of Man, and start the process of the offshore assets as soon as you're able to obtain the South African letters of executorship. And I think at that stage, I'll hand back to Kapil.
Thank you, Jeff. That very much doesn't sound like the Suez Canal in terms of how to approach grant of probate. Thank you for doing that. Is the deceased estate reportable to HMRC if there are UK assets?
I think that's something that advisors and clients often miss, which is that if you hold assets in the UK, you have to go through the UK probate or executorship process. And the HMRC, the equivalent of your SARS, will want to satisfy themselves that you are not UK domiciled. In other words, you're not liable to estate duty or inheritance tax, as we call it, on those assets. And of course, even if those assets are over £325,000 sterling, even if you've never ever been to the UK, they're called situs assets, and they would be subject to inheritance tax at 40, which is 40%.
Let's keep with the rapid fire. Who decides if probate is required?
Okay, the institution. So let's say you have assets with momentum in Guernsey. They would decide whether probate is required, and I believe from memory they set the level at £10,000 sterling.
Okay, who decides or sets the probate process?
Each individual probate court in each jurisdiction. So obviously in the UK, the various regional probate courts, Guernsey and Jersey and the Isle of Man from the respective probate courts, or as you heard in Guernsey, from the ecclesiastical court.
It all sounds very admin intensive. How long will the process take?
As I said before, from the time that you obtain the documentation and it's in the hands of the attorney, so don't forget it might have taken you 2, 3, 4 weeks, to get all the various documents certified and prepared. It can vary from between 3 months in, say, Guernsey and Jersey to sort of 4 to 5 months in the Isle of Man in the UK.
Do you need to employ the services or any agents or associates in the UK, Isle of Man or Jersey to assist you if you are based in Guernsey?
No, in Guernsey we're able to, and we frequently deal with estates in Guernsey, Jersey, the Isle of Man and the UK without any use of attorneys.
Thank you, Jeff. That was an incredibly insightful session. Jeffrey, in South Africa, you are up next. Are you playing hopscotch in a global minefield? When should a financial planner consider roping in a specialist on global matters?
Thank you, Kapil. One of the many challenges financial advisors face is determining their own boundaries and when to obtain specialist advice. There is no doubt that increasing globalization has introduced a level of complexity to estate planning, whether it be in relation to tax, succession, or the implementation of estate planning structures. While it is difficult to set absolute rules that must be followed, in the following session we identify a few principles that may be of assistance and also identify some of the complexities associated with certain issues and how they may be approached in practice.
How should financial advisors approach setting boundaries regarding the advice that they provide?
As financial advisors, there are certain things that fall squarely within our domain, such as developing financial plans for clients and advising on the implementation of products. Where it does become murky is that advice on certain products involves explaining their tax consequences, whether it be an explanation of five-fund tax and its effect on endowment policies, the tax deductibility of contributions to retirement annuities, or the estate duty consequences of certain death benefits. Why should this then be any different from advising clients on how they should fund their offshore trust? For me, the answer lies in the level of subjectivity that needs to be applied to a client's specific circumstances and the likelihood that someone may be required to defend the advice on behalf of the client with the authorities. The higher the level of subjectivity and the more likely the need to defend the advice, the greater the likelihood that a specialist should be roped in. Advice is often contrasted with guidance, and this may be a useful starting point in understanding our boundaries. In the United Kingdom, the Financial Conduct Authority describes guidance as an impartial service that helps clients to identify their options and narrow down their choices. It does not tell the client what to do. That decision remains with the client. A person providing guidance has a responsibility to ensure that the information that they provide is accurate, but the risks associated with providing guidance are less than those associated with providing advice. Guidance is generally offered for free. Advice, on the other hand, involves the recommendation of a specific solution or course of action and will be aligned to a client's specific set of circumstances. The liability associated with providing advice is much greater than providing guidance, and a person receiving advice has a legal recourse against the provider of the advice if that advice proves to be incorrect. It is usual for recipients of advice to pay for that advice. In many countries across the world, financial advice has also become increasingly regulated in recent years. We have also seen a tightening up of the provision of tax advice in South Africa, with the requirement now that, subject to certain exceptions, persons advising clients regarding the application of a tax act must register as a tax practitioner. It seems clear, therefore, that the authorities wish to regulate tax advice separately. When setting boundaries, financial advisors should first establish whether the advice required falls within their own regulated activities. If it does, then there's a good chance that they will be able to handle the situation on their own. Where it falls outside of these circumstances, then, such as how to fund and structure an offshore trust, then it makes sense to call in an expert.
Speaking of offshore trusts, the recent relaxation of exchange controls has meant that offshore company trusts may become viable options as estate planning tools for more South African investors. How does one navigate between guidance and advice in establishing these structures, and what expertise do we need?
The two main changes to exchange control regulations over the years have included increasing the amounts that individuals are permitted to take offshore, and most recently the lifting of the prohibition on loop structures. In broad terms, a loop structure is one where a South African exchange control resident takes money offshore to invest back in South Africa. Individuals establishing these structures need to identify and rope in their offshore service provider as soon as possible. And the client will probably also be required to obtain South African tax advice regarding the local tax implications of the proposed structure. When it comes to establishing offshore structures, it is becoming increasingly common for offshore trustees to require prospective clients to obtain formal tax advice in the jurisdiction where the client is resident before implementing the structure. While this may appear tedious and expensive, obtaining this advice provides protection to the trustee and also ensures that there won't be any nasty surprises once the structure is implemented. If the structure itself then wishes to invest in another jurisdiction which may result in tax consequences, then tax advice should be sought in that jurisdiction as well. For example, if the offshore trust wishes to invest in fixed property in the UK tax advice will be required, as this is a complex and tricky field.
Many South African families have family members scattered all over the world. How should we approach such situations, and what is the role of the financial advisor there?
A fairly common scenario for many South African estate planners is that they have family members scattered all over the world. I once came across a scenario where the estate planner is a South African resident. He has one child living in Australia, another in Israel, and yet another in the United States. While the tax and other implications of the local structure may be familiar to the South African resident, often the consequences of the various jurisdictions where family members are resident may not be familiar. Each of these jurisdictions potentially applies different tax consequences to the trustees and beneficiaries of trusts, and it's unlikely that you will find a single expert to comment authoritatively on the tax consequences of all of the jurisdictions. Certain jurisdictions don't even recognize trusts at all, and alternatives therefore need to be considered. Another similar scenario exists where individuals have links to more than one jurisdiction. For example, you may have a client who spends part of the year in Europe and part of the year in South Africa. If he wants to then create an offshore structure, he would need tax advice in the European jurisdiction and in South Africa to understand the full implications of what he's planning to do. Clients may be overwhelmed by the complexity of all the different pieces of advice that are required, and accordingly, real value can be added by assisting clients to identify suitable practitioners in those jurisdictions to provide relevant advice, and also for somebody to coordinate the various pieces of advice that are provided.
We are actually often asked about whether clients should have separate wills dealing with their assets situated abroad. Are there any specific considerations when it comes to having separate wills, and if so, what are these?
Well, the answer to this is that it depends. Where we are familiar with the laws of succession in a particular country and they're not dissimilar to South Africa, then a single worldwide will may be suitable. But where there's an element of unfamiliarity, then the advice of a specialist in that other jurisdiction should be sought. The law of succession is potentially complex, and it is not uncommon for us to assume that all countries apply a system similar to our own. In South Africa, we apply principles of freedom of testation. which means that a person may, by way of a will, bequeath their estate to whomever they want, which is why wills are so important in our society. There are some limitations to the freedom of testation, which typically include maintenance and accrual claims, and also bequests that may be regarded as unconstitutional. Freedom of testation doesn't apply in all jurisdictions, however. For example, much of continental Europe applies principles of forced heirship, whereby the law determines who is to benefit from a person's estate. This may be complicated even further if the person is domiciled in a country other than the one where the property is situated. In these cases, the law of the domicile of the person will apply to movable property, and the law of the place where the property is situated will apply to immovable property. When dealing with assets situated in Europe, one must also take cognizance of the EU regulation known as Brussels IV. This regulation deals with jurisdiction, the validity and admissibility of wills and succession agreements, and also the European Certificate of Succession. It all becomes very complicated, and it is therefore important to make sure that proper advice is obtained up front. It is always better to plan around the regulations while the client is still alive than to try and fix the situation once the person has passed away. By then, it may be too late.
In conclusion, what criteria do you suggest could be used when deciding whether to rope in a specialist or not, and what are the benefits to the financial advisor and client in doing so?
I would suggest that the starting point must always be whether the advice required falls within the scope of the financial advice that the advisor is providing to the client or not. If there are any doubts or concerns about the tax consequences of implementing a particular solution, then the client should obtain formal tax advice. In line with the definition above, formal tax advice should be given by someone who would be willing to argue the view on behalf of the client should the opinion be challenged at any stage. In other words, the person providing the advice must take full accountability for the advice, and it is therefore likely that he or she would want to charge a fee for providing the advice. The main advantage to the client of obtaining the support of specialists is that they are able to plan with a measure of certainty regarding the consequences of implementing the particular solution. For the financial advisor, it is the comfort of knowing that reasonable steps have been taken to ensure that the client is properly informed regarding what is proposed.
Thank you, Jeffrey. Let's turn our attention on Himna. Himna, should clients buy more life cover if they don't use an offshore wrapper?
Morning, Kapil. Let me start by saying that from a new business inflow perspective, the discretionary offshore Lisp products have always been popular in our industry. However, current trends have shown strong support for offshore life wrappers because of its potential tax, succession, and estate planning benefits to its investors. So let's unpack this using an example where we compare the international Lisp product, which we of course call the international investment option, to the international endowment option. So let's consider a family of 4 where the parents and their 2 children invest in an international discretionary investment product and select to have joint ownership. So this results in an equal ownership of 25% between the family members or contract owners. When the father passes away, his portion will automatically accrue to the 3 remaining contract owners. There is a CGT rollover relief, but the Section 4Q deduction applies only to the portion which he leaves to his wife. When she passes away, her portion will accrue to their children. CGT and estate duty will apply on the mother's portion of this investment. Now, for example, endowments work differently. Guernsey law allows for joint and survivorship provision between the spouses. So for the international endowment, let's say that the parents have selected the joint ownership and appointed their children as additional insured lives and successor contract owners. In this example, the parents own the contract, and whilst the children as insured persons and nominated successors have no rights over the investment while their parents are alive. So then, when the father passes away, his portion will accrue to his wife, and due to the joint and survivorship provision, CGT will not apply, and the Section 4Q deduction now applies on the full amount. The mother is then the sole owner of this investment. When she then passes away, the contract continues because there are remaining insured persons, the children. The contract will accrue to the children in their capacity as successor contract owners, and there will be no CGT. estate duty will apply within the mother's estate as a deemed asset, of course. In each of these two above examples, neither probate nor executive fees, which we have now discussed at length, will apply because there is no need to consult a will due to the way in which these investments were structured.
Himna, so if I can summarize, although both products allow for joint ownership of the investment, only the endowment allows for joint and survivorship provision between the spouses.
Yes, Kapil, that is absolutely correct. However, we also need to discuss the two variations of the endowment wrapper, the life insurance bond and then of course the capital redemption bond. The life insurance bond allows for an unlimited number of contract owners. The contract owners can, in addition to themselves, also appoint an unlimited number of lives insured. This solution also allows spouses the option to select the joint and survivorship provision, which we of course discussed earlier, and the investment structure and its appointed role players determine the outcome in the event of the death of one of the contract owners. Both successor contract owner and beneficiary for proceeds nomination can be used for effective estate planning, allowing for the unique needs of each of the investors. Then secondly, Kapil, the capital redemption bond, which is of course a sinking fund structure. It allows for unlimited contract owners, but it does not have lives insured. This structure allows for both joint and survivorship provision between spouses, as well as for contract owners to nominate successor contract owners, which will ensure continuation of the investment when the original contract owners pass away. This product is often used by entities to allow for the longevity of the investment. So in summary, the Momentum Wealth International product offering, if applied and structured correctly for a client, offers all the benefits required to ensure that investors will not need additional life cover. It of course always depends on the amount invested and whether sufficient provision for estate duty has been created in the estate.
So Himna, is a trip to Lesotho international travel? Can a local Lisp cater for all of your clients' offshore needs?
Interesting question, Kapil. Aren't we also ready to pack our bags? But back to your question, although a client's needs could be met by both local and international platforms, there are a few key considerations when selecting the most suitable solution for a client. For example, the difference in the fund range available to meet the investment needs, the impact of VAT on service and administration fees, contract structuring options available for succession planning, and of course the tax implication on the investment return. But I think let's go through some of these in a little bit more detail. True internationally domiciled platforms generally offer a wider range of foreign currency denominated investment components to choose from compared to your typical local platform. You also, of course, have access to components such as international share portfolios, exchange-traded funds, and of course international model portfolios. Given the wide range of components available, it is more likely that a client's investment and portfolio construction needs would be fully met by the choice of a truly international platform. Then, in terms of estate planning, international platforms generally offer many more options to natural person investors because of different legislation. For instance, local Lisp product can easily allow for single contract ownership, but our international platform allows for single or joint ownership of contracts, and as I mentioned earlier, the option to have joint and survivorship provision between spouses. This allows, of course, then for continuity on death of a contract owner and saving the executive fees that Jeff in Guernsey was talking about earlier. VAT is applicable on local platform fees for certain products. So Kapil, the client could be in Lesotho, yet still pay South African VAT on its administration fees.